Morning, everybody. How you doing? Hope you're ready for some court. Got about 2 hours worth coming ahead. Good morning, good morning. Good afternoon, good afternoon. Wherever you are, wherever you may be. Welcome to Lone Wolf Usul's Weekend Review. Court cases and all kinds of cool stuff. Mostly just court cases, though. That's all we have really time for. That's it. But we're back. We're back here for another 2-hour full, how you guys doing? Hadn't seen you guys in 4 or 5 days. Good to see you. Good to see you. I have put together for us today a block of Judge Boyd, a block of Judge Stevens, and a block of Judge Fleischer, as you may have noticed in the thumbnail there. The Boyd's pretty interesting. Well, they're all interesting. There's no reason to really talk this stuff up. It's all good. I've tried to curate this for our enjoyment, and a lot of this I'm going to be watching right alongside with you. I make the videos, you make the comments. We do it live right now. Let's enjoy some court together. Thank you guys for showing up. See you.
All right. Thank you. All right. Court is going to call 2024 CR 007361, 2024 CR 007359, State versus Johnny Abel Munos. Can I have parties announced for the record for the state?
Daniel S. for the state of Texas.
For the defense?
Adrian Bettis.
And are you Mr. Munoz?
Yes, ma'am.
All right, you entered a plea in each of these cause numbers on September 10th. You entered a plea and the cause number ending in 59 to count 1 and count 2. You entered a plea of guilty and you pled true to the repeater allegation. And the cause number ending in 61, you pled guilty to counts 2 and counts 3 and true to the repeater enhancement allegation. In each of the cause numbers, the court found there was sufficient evidence to find you guilty of each counts and found the enhancement true. According to your plea bargain agreement, punishment is to be assessed at a cap of 40 years in the prison. There's an affirmative finding of a deadly weapon. There are no applications. The cases were run concurrently. The state is taking in consideration 2024 CR 5164 and 2024 CR 007370. In each of the cause numbers, counsel, you waived PSI, is that correct?
Yes, Your Honor.
All right. The court has reviewed the defendant's criminal history without any objection from the defense. And it's the court's understanding. Do you have any witnesses?
No, Your Honor.
All right, then the court will hear argument. Defense, you're asking for, I'm assuming, 40 years. Is that correct?
State Judge.
I'm sorry, state.
Yes, Your Honor.
And just one moment. Excuse me. On this case, I don't have the stipulations. On both cases. It's 2024 CR 007359 and 2024 CR 007361. No problem. All right, state, I'll hear your argument.
Judge, this case is an incredibly serious one. These were called out for suspicious person at this motel.
All right, just one moment. Excuse me, everyone. You all need to whisper as though you were spies. If you cannot do that, then y'all need to stop talking. All right, you may proceed.
They're investigating a suspicious person at this motel. When they arrived, they attempted to locate the defendant. And one of the officers was looking down a hallway. He was shot at by the defendant. The officers had to take cover. Several people from the motel from inside their rooms came out. The defendant at that point forced him at gunpoint to let him in the room. He then let them go, but continued firing at officers. He then also fired at others through the walls of the motel and could have killed several other people. Several people had to evacuate the room. Several people had to lie down on the ground to avoid any type of gunfire. This is incredibly serious. We think that 40 years is more than appropriate here. He could have killed multiple officers and multiple bystanders.
All right, defense.
Judge, this in fact is a serious case, but Johnny has serious problems. And I'm asking that the court give him mercy today. And I am asking for the minimum 15 years. I'd ask the court to take judicial notice of the court's file. In it, there's a competency report that was completed. And in that competency report, the doctor notes a few things about Mr. Munoz, which I think frankly should be taken into account and decided his sentence. Mr. Munoz appears to have a mental illness of some kind. It's never been diagnosed, but the doctor did review records, medical records, did talk to his family. His father did have a mental illness, and it's been suspected that Johnny has one. Johnny got locked up at 12 years old for the first time. He has had trouble with drugs and alcohol. He is an alcoholic, and on this particular occasion, he states that he was on a bender, and it certainly doesn't excuse what he did. He knows he's responsible for what he did, but he did what he did because he was on drugs, and he was on drugs because he has an addiction. So we have a cycle that Mr. Munoz has been having to deal with his entire life. And yes, this could have gotten very, very bad, but thankfully it didn't get as bad as it could have. I think that Johnny needs to hopefully be put in a therapeutic community at prison. I think that he needs a whole bunch of counseling, a whole bunch of classes, and I hope that TDCJ is going to offer that and that he takes full advantage of that. But I don't think that he's a monster that needs to forfeit the balance of his adult life. I think that an appropriate sentence would be somewhere in the 15 to 20-year range, and that's what I'm asking that you do. Thank you.
All right, so I have several questions. My first question is, what is his mental illness?
I don't think it's ever been diagnosed, Judge, and I don't want to tell you that for sure he has one. Frankly, given the facts of this case, I thought from the get-go that I should file a competency exam, also based off of the defendant's initial behavior. That very well might have been just because he was on drugs, but there, as far as I know, there's not been an official mental diagnosis.
So he is competent,
Yeah, oh, yes, yes,
and he was sane at the time of the offense.
yes.
All right. So then here's my next question. Previously, he went to prison for aggravated assault with a deadly weapon. Is that correct?
Yes.
So why did he have a gun? Because he's not allowed to have a weapon.
I don't have a good answer for that, Judge. He shouldn't have had a gun. And I know that I'm asking a lot, but that's my job to ask for a lot.
No, I understand.
And I know very well, Judge, he might not be he might not be deserving of mercy, but that's kind of the point of mercy, is to be merciful to the people that don't deserve it. I'm just asking that you show him a little bit of grace today, Judge.
All right. I don't think 15 years is appropriate for this offense. For the aggravated assault with a deadly weapon, how long was he in prison?
15 years.
So he was in prison for an aggravated assault with a deadly weapon for 15 years. And previously in his criminal history, he was placed on deferred adjudication. What was that offense? Was that the deadly conduct?
I believe so, Judge. The ag assault, he was convicted and placed in confinement in 2008 for 15 years. Trying to find the deadly conduct, he was convicted and also placed on for 15 years.
All right. All right, this is where I'm at. And I will tell you, whenever you go to judges school, they always tell you, say as little as possible on the record, right? But I'm a firm believer that when you explain to people a little bit why you're doing the things that you're doing, so people won't think it's arbitrary. When I was a defense attorney, I would always feel that people were just randomly maybe throwing out numbers. And I'm not saying that the state is doing it in this case. I think the offer that they tendered is an appropriate offer in this case. A lot of times when people have cases that are aggravated assault with a deadly weapon, if somebody's pointing a weapon at somebody, if somebody's showing a weapon at somebody and threatening them, people focus a little bit of what might have happened. Well, this could have been a murder, so you should sentence him to 40 years. I do know that he has maybe some mental health issues. Maybe that's brought upon the fact that he has been in and out of custody since he's been 12 years old. And if you have somebody who's in and out of custody since they've been 12 years old, I know that there is an issue, perhaps parenting, because I don't take the idea that there are bad seeds. I don't think a child is born and everybody says, I knew since the time that child was born, time when they threw their bottle out of the crib or threw up on somebody, I knew that child was going to be a problem. So I think a lot of it has to do with environment. I think a lot of it has to do with parenting. Of course, there are issues with drugs, alcoholism. That really is not an excuse for behavior. So I want you to know that I reviewed everything, and the reason why I remember your case and I remember you, and the reason why I asked them to give me the stipulations again is because I want to be sure of everything that I read and make sure that my memory is correct on things. Of course, you know, this one is not an appropriate situation for probation because that's been tried with you before. All right. Is there anything you wish to say before I pass ruling? All right. I want to let you know that I wish you the best in your life, but you're going to be going to prison today. The cases were run concurrent with each other. And I want you to know, even though we're dealing a little bit in what ifs, you should really consider what ifs, because you could have killed officers that day. You could have killed people who were just at that hotel trying to get a good night's sleep. You understand? And each cause number, the court will take into consideration 2024 CR 5164, 2024 CR 007370. I'm going to recommend for you the therapeutic community mental health unit. I don't know if they'll accept you into that unit based upon your criminal history, but I do know that if you don't request it, you definitely will not be placed in that. I have no jurisdiction to order them to place you in that community, but continue to ask for it.
Yes, ma'am.
All right, and how old are you?
43.
All right. The court is going to sentence you to 35 years in the prison. And give you credit for any time served. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
Yes, ma'am.
Did you understand it and sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing, I realize that's, oh, and I'm sorry, in each case, there's an affirmative finding of deadly weapon. All right, we can go off the record. Here's the thing, I know that's a lot of time. And I realize how old you are, and I realize that prison time is hard time, right? But this is what I want you to understand. One, this is a part of punishment. But two, nobody ever knows how long they're going to live. Nobody ever knows what's going to be happening with parole. But what you need to do is make sure that you get your life in order, right? And be the best that you can be. And at prison, do not become institutionalized, because it's easy to become institutionalized. It's easy to go to prison and become a part of this thing where you're just committing crimes in prison and other people are committing crimes around you or towards you at the prison. Don't become institutionalized. Just try to be the best that you can be each day. And, you know, look forward to go in there with the understanding that, hey, there's a great chance that I'm going to end up getting parole, and just try to better yourself. So when you do get paroled, that you're ready to be in society, do the right things. And if you need to be on medications, to be on medications. And if I'm still here, who knows what will happen, right? But if I'm still here on the bench and you are lost, don't know where to go to get help, you can always come back and see me, okay?
Yes, ma'am.
And I say, if I'm still on the bench, who knows? Maybe I win the lottery or something. I don't know. All right.
All
So
right.
good luck to you, okay?
Thank
You're welcome. Thank you, counsel. Thank you. Adrian, I have this for you. Sorry. Frank Torres. Almost done. Okay. Court is calling 2024 CR 007992, State of Texas versus Frank Torres. Can I have parties announced for the record for the state?
Daniel Rosengart for the state.
Defense?
I'm gonna say that.
And are you Mr. Torres?
I am, ma'am.
Counsel, you received all of the discovery. Did you review it with your client?
Yeah.
Court will find that the state is in compliance with discovery. Is there an application?
Nope.
All right, Mr. Torres, did you review the document entitled True Bill of Indictment with your attorney?
Yes, Your Honor.
Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Your
State, are you proceeding on the indictment as presented?
Honor. Yes, Your Honor.
Mr. Torres, did you review the court admonishments with your attorney? Did you understand it?
Yes, Your Honor, I did.
All right. State,
I'm sorry, it's gonna be a reduction to the proceedings.
all right, any objection? Okay. All right, according, the state is proceeding on a lesser included offense of assault, bodily injury, family as a class A misdemeanor. Range of punishment is up to 1 year in the Bexar County Jail and up to a $4,000 fine. Did you understand?
Yes, ma'am, I do.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor, I do.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea, you are giving up those rights?
Yes, Your Honor, I
And
do.
did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses? Do you believe he has a rational as well as a factual understanding of the
Yes.
charges against him?
Yes.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, both.
Mr. Torres, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
I am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor, I did.
According to the plea, the state is proceeding on the lesser included offense of assault, bodily injury, family as a class A misdemeanor. They're asking that your punishment be assessed at 135 days in the Bexar County Jail. There are no applications and there's an affirmative finding of family violence. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, Your Honor, I do.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent? Did you understand?
Yes, Your Honor, I do.
Did you understand that to be the plea?
Yes, Your Honor.
Defense, is that the plea?
Yes.
State, is that the plea?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am, I did.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counselor, have there been any such motions?
None, Your Honor.
Outside the agreement, the state is requesting no contact with the complainant. Did you understand that's a recommendation from the state and the court does not have to follow that recommendation?
Yes, Your Honor, I do.
Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
Guilty, ma'am.
State any evidence.
The state offers State's Exhibit 1 and attachments.
Okay.
State, have you talked to the complainant?
Oh, we have and we will be speaking with her after as well.
All right, you may be excused.
Thank you.
Did you review the document entitled Waiver and Consent to Stipulation of Testimony and Stipulations with your attorney? Did you understand it?
Yes, ma'am, I did. And I do.
And did you sign it in all the appropriate places?
Yes, Your Honor, I did.
Again, did you understand you have a right to a jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am, I do.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am, I do.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. After reviewing State's Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will find you guilty. The court will sentence you to 135 days in the Bexar County Jail. There's an affirmative finding of family violence. The court will give you credit for any time served. There's to be no contact with Sonia Esparza, and there's to be no contact with the offense location on East Woodlawn Avenue. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it?
Yes, ma'am, I did.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, You do not have the court's permission to appeal. Do you understand?
Yes, ma'am, I do.
Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am, I do.
All right, we can go off the record. Do you love the complainant?
Absolutely.
No, you don't, because if you did, you wouldn't put your hands on her in
Absolutely.
anger.
That's.
So-
definitely. Yes, ma'am.
No, you don't. That's not love.
Yes, ma'am.
And if you think putting your hands on someone in anger is love, then you don't know what love is and you need to look it up.
Yes, ma'am.
But that is not.
Yes,
And
ma'am.
you are not to have any contact with her and you're not to have any contact with that location.
Yes,
And
ma'am.
if you do, a warrant will probably be issued for you
Yes,
for
ma'am.
violation. Do you understand?
I do.
All right, good luck to you.
Thank you, ma'am.
You're welcome.
Maybe two times.
Yes.
So that last little dressing down, I know everybody was probably sitting there for a few minutes. I was actually like, why did I put this clip in here? And then it hit me at the very end right there. Like it probably hit the rest of you. That was a nice little dressing down. And 35 years for the other guy who shot up the hotel. That was just why. I mean, I had not heard of, like, I don't know how long ago that happened or anything, but that I just found that whole situation, the look on his face. I'd never really, I don't recall ever seeing anybody getting that much time in one lump sum. It was just real interesting. All right. We're going to go from Boyd, Becker County. Did I say that right? To Beaumont County. Judge Stevens. And you know, Judge Stevens is always interesting. To me, at least. The man is aged and wise. See what he's got to say.
Courtland Woods, is that you?
You're not in front of me, Judge.
Yeah, in front of her first, please. Thank you.
Raise your right hand. You swear or affirm to tell the truth and nothing but the truth, so yes, ma'am. I'll give you a light, something. You're gonna place it. Hold on. You're on the box.
Here they come.
Look. Yeah. Take it up one more time.
We said a prayer. We had a funeral for the computer and we wish it best in
Mine's messing up now. If y'all
computer heaven.
Care to forget it.
23 CR 202 is called the State of Texas versus Courtland Woods. Is that you?
Yes, sir. Yes, sir.
Present with your attorney, Mr. West, and the state's attorney. Does the defendant waive a formal reading of the motion to revoke unadjudicated probation filed July 29th, 2024? Can we proceed in summary?
Yes, sir.
In summary, this motion states, ma'am, and raise your right hand. Do you solemnly swear or affirm any statements you make during this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Lower your hand. This states that on January 29th of 2024, in this court, you were placed on 10 years deferred or unadjudicated probation for the second-degree felony of assault on a peace officer. Is all of that true?
Yes.
One states you failed to report to the Jefferson County Probation Office on or about March 27th, April 22nd, and June 20th of 2024. I guess you absconded. She took off.
Not
right?
a absconder status, but she didn't report.
She's
For-
never with this.
She was put on probation in January
Yeah, I know.
and
I did stronger. That sounds bad. It's not what I did.
Okay, was it, well, were these successive times she was supposed to be reporting? Was she reporting monthly?
Yes, it was supposed to be.
Well, it says she didn't report in March, April, and June. Did she report in May?
No, she-
Well, that would include it. What about July?
That's when that much was filed.
It would have been after she would have had to have reported.
Oh,
So the last time she reported, okay, so she was placed on probation in January. So we have a February report
Yes,
date,
she did intake that day and then she reported March the 6th.
March 6th, and then that was the last we heard from her,
Yes.
which means you absconded.
I left a voice message. I've talked to you and on.
Did you show up in person or not?
No, no, sir.
Isn't that what you were required to do?
Yes.
Okay.
I
So,
apologize.
and so, what happened? Were you arrested?
Yes,
When?
2 months, last month.
Last month. So we're talking about in August?
Yes.
Where were you arrested at?
I was arrested in New Orleans.
And where? Nederland. Nederland. Okay. Would you forget to come
Yeah,
in?
No, I just.
You didn't forget. I know. Well, what? You're
I just-
bouncing around. Relax. Did you,
Yeah.
you have to go to the restroom or something?
No, I
Okay.
was just nervous. I was home to home and I'm homeless, going from home to home.
I know,
and-
but you guys, but you have an obligation. If you can't do anything else, and there's a lot of conditions of probation, and a lot of those we pass for folks who have issues. But the one thing you have to do is report, or else
I will.
don't
report.
interrupt me.
So yes.
You have to report, or else you're really not on probation and supervision. If you're not connected to us, then you're not supervised, which is the whole essence of what not going to prison, the only alternative, which is your only alternative if you don't get supervised and follow the supervision terms.
I was diagnosed with schizophrenia in 2024 and I'm.
Nonetheless, nobody said you were incompetent.
Yeah.
Nobody said you're insane. And everybody has issues. No one's perfect. So that's, everybody's a little imperfect.
Yeah,
You're just welcome to the planet. All of us are that. Nobody's perfect in this room right here. Nobody.
I understand.
So we
sir.
all deal with our issues, but we have to work with them to fit what the requirements of life are. And these requirements are for anybody.
I understand, sir.
All right.
I understand.
Don't think, I don't know if you feel like, well, I'm imperfect, so I get to pass. No, you can be successful just like anyone else.
Okay, thank you, sir.
You have the capability. How far did you go in school?
I dropped out in 8th grade.
Okay. I bet you made good grades though.
I didn't, no, sir. I have a learning disability.
Okay. What do you mean?
I have a retainer.
Okay, and bad memory?
Yeah,
All right.
but yeah, I dropped out in 8th grade.
All right, because I know a lot of people who do drop out early and they're still almost savants. They're high intellectual people, which means you could be high intellectual as well and just have a learning issue. But nonetheless, you know this one thing, that failure to follow the rules has consequences.
Yes, sir.
Okay. So we didn't report, we were absconder, you pleading true to that voluntarily and because it is true.
Yes,
Do you understand? By a plea of true, a
yes, sir.
voluntary and knowing plea of true to one or more violations of probation, that is enough to grant these motions to revoke probation. Your probations can be revoked. You can now be found guilty and sentenced up to the full range of punishment. And we're talking about here a second-degree felony. You're looking at no less than 2, no more than 10 years confinement in prison.
No more than 20.
I'm sorry, no less than 2, nor more than 20 years confinement in prison. See, there I go, making a mistake. Understanding the consequences of pleading true, do you still insist on pleading true today?
Yes,
I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true. My battery is running low here. Why does that not surprise me? Today's one of those days. An agreement has been reached here where you would be found guilty, sentenced to 10 years in prison. That would be suspended and you would be placed on regular probation for up to 10 years. Is that your understanding of the
Yes, sir.
agreement? If I follow this, you have no right of appeal
I will show up and I will report, sir.
of your case. Do you understand?
Yes, sir.
So you'll hear what's marked as State's Exhibit 1. I'm going to ask you if you sign that, discuss it with your attorney. Is everything true and
Yes, sir.
correct?
Yes, sir.
State's Exhibit 1 tendered into evidence.
No objection.
Without objection admitted. Among other things, this states you are mentally competent to enter your plea, which is freely and voluntarily made. You were admitting true to this violation of probation. And you understand the consequences of pleading true,
Yes,
and that you will be placed on regular probation, and this is your agreement that you agree to, so help you God.
So, yes. Sir.
States Exhibit 1 is made a part of the record for all purposes, and you are also waiving any right of appeal. If I follow this agreement, I am going to and find you are entering your pleas of truth voluntarily, your plea of truth voluntarily, knowingly, intelligently. That is enough to grant this motion to revoke probation by a preponderance of the evidence or greater, and your deferred or unadjudicated probation is hereby revoked. Earlier in this case, you pleaded guilty voluntarily. You were mentally competent to do so. You understand the consequences of pleading guilty. There was sufficient evidence supporting your guilty plea for State's Exhibit 1 admitted to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt. I'm following this agreement of this underlying offense here of assault on a peace officer. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years. That is suspended. You were placed on regular probation for 10 years. There will be terms and conditions of probation, which are normal and customary for that type of offense. Make sure you follow that, or your probation can be revoked. You can be sentenced up to 10 years in prison. You don't want that. So please follow the rules. Thank you, ma'am. That is all.
Thank you.
Laurie?
Yes.
You're up. Get up. Okay, it's Freeman.
Yes, you'll have to come in front of me.
It's off the trial docket, Judge.
Ma'am, you'll have to come in front of me. Okay. Raise your right.
I'll tell you.
Swear or.
It's just frustrating, but there's an old saying that says, just stay in it. You either stay in it or stay out of it. And if you stay in it, it'll go up and down, but in the long run, it always goes up. And if you try to time it, you're always, it will always outwit you. 23 CR 955 is called the State of Texas versus Courtney Freeman. That is you? Present with Ms. Brozo, your attorney and the state's attorney. Does the defendant waive a formal reading of the indictment
It's only the first paragraph, Judge.
and arraignment? Can we proceed in summary?
Yes.
In summary, paragraph 1 of this indictment alleges that on or about May 18th, 2023 in Jefferson County, Texas, you committed the third-degree felony of injury to a child
Or elderly.
or elderly person. It says elderly, disabled, or child. So it's an elderly person or disabled person, one of those. Is that your understanding? Do you understand what you're charged with?
Yes. Sir.
All right, this is a third-degree felony, which means you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. You understand?
Yes.
An agreement's been reached where you would be pleading guilty, sentenced to 4 years in prison and giving up all rights appeal. If I follow this, which I intend to do, is that your understanding? If I follow this, you have no right of appeal. How do you plead to this, guilty or not guilty? Are you pleading guilty voluntarily and because you're guilty? Show you what's marked as State's Exhibit 1 there. Did you sign that document voluntarily?
Yes.
Understand it, discuss it with your attorney, or the contents all true and correct?
Yes.
State's Exhibit 1 is tendered into evidence without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea, which is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes.
Is a pre-sentence report waived?
Yes, sir.
I'm going to follow this agreement, if nothing further, and find that you were pleading guilty to this injury to an elderly person charge, a third-degree felony, voluntarily, knowingly, intelligently. There was sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this charge. I'm following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 4 years. Do you understand what has happened today, ma'am? You will be given credit for all time you have served in conjunction with this offense. Anything else?
Yes, sir.
That is all. All right. We are in recess.
Thank you, Judge.
At 1:30. Thank you. 16-25251 is called Jorge Graviel Cordona. Is that you?
Yes, sir.
Present with your attorney, Mr. West, and the state's attorney. What are we going to do today?
Your Honor, I think he's gonna plead true to this and let the. court
Unagreed?
decide.
All right.
That's the impression I'm getting. You want to.
All right, raise your right hand, sir. Do you solemnly swear or affirm any statement you make during this hearing will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes.
Lower your hand. All right, in summary, can we proceed in summary? There's a motion to revoke unadjudicated probation filed August 15th, last month, 2024.
Yes, Your
In summary, this states that on December 12th, 2016, in this court, you were placed on 10 years deferred or unadjudicated probation for evading arrest or detention with a motor vehicle, a third-degree felony. Is that true? One, states you failed to report to the Jefferson County Probation Office for the months of May and June 2024 in violation of your probation order. Is that true or untrue?
It's true.
Are you pleading true to that voluntarily and because it is true as it is alleged? Yes.
It means you should plead true.
Is it true as this, as I just read it? Do you understand by a knowing and voluntary plea of true to a one or more violations of your probation, that's enough to grant the motion to revoke probation? Your probation can now be revoked. I can find you guilty of this evading arrest, third-degree felony, and you are subject to no less than 2 nor more than 10 years confinement in prison, and a fine up to $10,000 could be assessed. Well, a fine of $500 could be assessed. That was the fine ordered. Do you understand the consequences of pleading true? This is what could happen. Knowing that, do you insist on pleading true today? Yes.
Yes.
See, you have to speak out for people. I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true. Now, there's one other violation that you are arrears and payments of fees and other required costs. But I'm more concerned about this situation of failing to report. Okay, so from the probation office, was he an absconder in May?
No, sir, he was not.
What
So,
happened?
the last time he reported to the probation office before the administrative hearing on July 22nd was April the 24th of 2024. So when the administrative hearing was conducted, he was approaching absconder status.
Okay, did he appear for that hearing?
Yes, sir, he did.
Okay, so he's gone for 2 months.
Yes, sir.
But you've been working for 8 years here. Why would you not show up?
Well,
That's important.
This time schedule is like they have me in the morning now. Since
At work?
well, I mean to report to probation,
But
and at work it's I have a time schedule because I ride the bus to work. It's like I don't have a time.
where do you work?
For Bechtel and to be over there and to be taxed. So they.
How much do you make an hour?
I make $24 an hour.
That's $60,000
Yes.
a year without overtime. I mean, that's a great job.
Yes, but
You don't want to ruin that.
well, I don't. I mean, I
Do you have a
already-
family at home?
Yes, sir.
How many?
I got my mother and my 2 kids.
Okay, you're taking care of them. Well, they rely on you. What's going on when you're in jail? They can't.
Yeah.
You don't want to lose your job, do you? Did you lose your job because you're here?
Yes, sir. I lost my job.
That was one of the things, Your Honor, he was having to report to probation, and he was causing problems with work because they were
Why?
letting him off work. They were.
'Cause I used to have late nights before I went to TVC.
Well, this is all workable,
But-
really. If you could get with the probation office, we want you to
Yes,
work.
That's what
they
we're-
wanted me to.
That's what we're going to ask for, Your Honor, if the court will continue him on probation because of this issue and let them work out a better schedule that works once he gets another job. He'll be able to get another job.
What state's saying?
I've kind of gone back and forth on this because while he was on probation, he actually got a 10-year sentence to the penitentiary for drugs. And so he knows he needed to kind of make sure he didn't stub his toe again.
Yeah, this isn't a substantive crime, though.
No, sir, and I understand that, Judge. That's why I've gone back and forth. I don't have a problem with it.
Yeah, he's this work thing,
You know.
but are you gonna be able to get hired back there?
They
You think?
say that I will, since I had to quit because they want to give me a time frame, so I have to get. They will probably hire me in February, 6 months from the day I got
But he'll be able to get another job in the meantime.
Maybe you can get another, what did you do over there?
Iron worker, structural iron worker.
Well, there are other ironworking jobs.
Yes, I just got a.
Okay, yeah,
Yeah, he'll be able to get another job in the meantime, but he's trying to get back with Beck. It's a good company.
okay. Here's what I'm going to do though.
Your Honor, could I? say
Yeah, I'm
something, please?
sorry. Yeah, you know best.
I'm sorry.
Yes, sir, from the probation.
This motion to revoke was at the request of the defendant. We conducted this admin hearing, we notified him that continuing to failure to report and failure to pay could land him back in front of you as it is today. He said that that's exactly what he wanted. He wanted to be back here today. He said he didn't have time to report to the probation department.
Oh, he wants to be revoked and sentenced?
You're right.
At the time of the administrative hearing, that is what was said.
Okay,
He said that he's already been to prison before on this,
so it's no big deal.
and he said that there was a mistake made by the court.
I made a mistake? Did I? For what? What was my mistake? You made the mistake.
Yes, sir. Right.
You're
But
blaming everybody else?
I'm not, I mean, at that time, I was kind of not having a good day, and thinking what I said it just out of impulse, so.
I think, Your Honor, at the time that he was upset because of the work schedule wasn't getting worked out. And I think it was
Well,
frustrating.
be careful what you ask
Yeah,
for.
Yes,
You might get granted
that's what he got.
what you want. And then try to get yourself out of that.
But I
What
think-
is it you want to do?
Well, can I speak?
Yes.
Well, the delinquent amount where I got sentenced, it built up, so I had a delinquent amount. They didn't want to give me late nights in order to pay that amount back, so they can give me late nights. But like, how y'all want me to pay something that I was incarcerated for that I couldn't pay? So I wanted to have late nights so I can report.
You can work a good schedule as long as I know about it. I talk it over with the probation office. If they're okay, I'm okay, because we want you to succeed.
Late nights will be better for me.
And Your Honor, we were working around his schedule.
I'm sure you were.
It's
They
been-
are easy to
It's
work
been
with.
continuous over the past year to year and a half that there's been numerous failures to report.
I think, Your Honor, him being in jail and seeing this, I think he's decided that he needs to do everything he can to work on this. And like I said, this is just an administrative issue.
Mr.
He may do-
Cordona,
he may
do you
do-
want to go to prison or not? You're looking at, yeah,
10 years.
up to 10 years in prison. That's not what you want. All right. Do you want to be independent, take care of your family, which requires you staying out of prison and getting a job and keeping a good job?
Yes.
We work backwards to help people do that. That's what we want. And every case is a little different. We work with everybody in their unique circumstances. You're not different. You got to work it out like a responsible person, or else you're going to go to prison. But the rules are the rules, but we are flexible as long as you do your part. I don't want to hear you back here saying it's somebody else's fault. It's going to be your fault next time because we're going to work with you. But you got to do your part by putting 100% effort in the right thing, or else all of that time and responsibility is lost. You don't want that. All right. Here's what I'm going to do. I'm going to find that there is sufficient evidence supporting this motion to grant it by preponderance of the evidence or greater, as the defendant has pleaded true to allegation 1, voluntarily, knowingly, intelligently. But I'm not going to revoke. I'm going to postpone any further action on this, except you are required to fulfill your terms and obligations of probation. I want to review this in 6 months, how we're doing. Unless you fail, and then you're going to be up here fast. And let's work this out. This is workable, but we'll review it in 6 months. You don't want a revocation, and you don't want to go to prison for 10 years, and all of that is something that can be fixed. Do it. And work with the probation office. They're easy to work with. If you have a problem, you talk to him. You understand? Okay. Anything else?
That's right, Your Honor.
All right.
Thank you.
We're in recess. Thank you.
Well, guys, we're here. We're here to the Fleischer Dome, Harris County. And today I did something special. I've done these before. I like doing them. This is going to be a week in Fleischer outfits, basically. The cases are interesting too, but let's just be honest. Sometimes one of the more interesting aspects of Judge Fleischer's courtroom is his attire. We all respect his excellent taste, and today is going to be another homage to an awesome week in judicial. I can't think of all the fancy. I'm trying to think of all the fancy words for clothes, but I can't think of them. I'm too Southern. I don't know what to say. But guys, we got some Fleischer coming up. It's about an hour. We're going right into it.
This is Christian, I'm Terrence Walker. I've been told that.
Where's Mr. Walker now?
He was just here.
Mr. Walker, come up. Deputy, I might need you.
Hold on. Just so everybody knows I'm not crazy, the word I was trying to think of was couture. That's the fancy word that I was trying to drum up out of my... I thought about it as soon as I started the video. I was like, oh yeah, I was trying to think of couture. That's the word I was trying to think of. And then Mom was like, you could just say garments, and I could, but couture was what I was really looking for because I was trying to be fancy. And we're just gonna start this block back over because I'm a blockhead. Love you guys. Love you, Mom.
This is Christian, I'm Terrence Walker. I've been told that.
Where's Mr. Walker now?
He was just here.
Mr. Walker, come up. Deputy, I might need you real quick, ma'am. Okay.
The issue is that he's testing negative, but it's showing for the lab result diluted. And Judge, I don't know why it's showing that, but
I know why.
Well, I don't know how much. My question would be, how much water does someone have to consume for it to show diluted?
They have other things that you can take at high times that will dilute it. It's not just a matter of drinking 15 gallons of water. There are other masking agents that they use to dilute to.
If someone takes a diuretic.
Well, I don't know about a diuretic, but I mean, just there are other things that you could take at high times to mask what you're doing. And I told you now, a dilution was just as good as testing positive with me. With all the drama you've given us, absolutely not.
I've been on the diet. I've been on a strict diet, so I haven't been drinking a lot of soda. Or I barely drink water. I barely drink juice. I've been drinking a lot of water. I've been cleaning out my system, flushing out my system to make sure I stay clean. Because, like you told me, and like I've made sure that my lawyer know, I'm trying to stay clean, trying not to mess up in any way. Sir, I'm telling you, I have not. I've been completely clean, sir.
I want to do a deeper dive because I want to know more about the dilution. I'm not taking your word for it. Like
Sir.
You telling me something goes in one ear, goes out the other ear.
I'm telling you, I've been listening to you. I do not want to go back to jail. Everything I'm supposed to do. Like I said, I've been on a strict diet a lot, and I have been drinking a lot of water only because it flush out my system to get the THC out. That's it. I've been drinking a lot of spring water, cucumber water, and juice and cucumber.
Because of your prior positive.
Yes.
Not because of a new positive.
No,
Correct.
because my prior positive you got on me. You said if it happened again, and I've been drinking a lot of cranberry juice, a lot of water that's flush out your system. That's just natural way I've been trying to get out all the THC out.
I already told you what was going to happen. If
Yes, sir.
I
Yes, sir.
diluted sample, and they're telling me how many diluted samples are you saying? So regardless, I'm not making a decision now. We need to hear more.
Yes, Judge.
Yes, sir.
Keep me the jury box.
Yes, sir.
Okay. See if we can get some information.
Yeah. I mean, if it's a diluted sample, it's.
Judge, I don't know under what circumstances those pop up. If they're only popping up if someone drinks more water than the average person.
You have to drink I don't know, we'll see.
Yes, Judge. Are you okay for approaching now? And so Judge, on Mr. Walker, I don't think we have any like additional information as far as the dilution. But is there any way, Judge, we could just reset it to Thursday and see if we can not have a diluted sample? You know, I think he's just drinking water, Judge.
Leave it for a second and come up, Mr. Terrell. Not Mr. Terrell, it's Walker, that's right.
And all of his, everything that they says for is negative except for keratin. It came back a abnormal level, but they can't say that.
You can't, there's a diluted sample, so you can't really tell because it's all masks. It's all masked because of whatever he's doing to dilute the sample. So that's the problem, is he's doing something to trick us into diluting the sample so we can't tell what he's taking. Mr. Walker, you have open at this time a possession of marijuana, 2 to 4 ounces, a possession of a controlled substance. You pick up another possession of 4 ounces to 5 pounds. You have a DWI with a child passenger, which is, what is it, like a 3-year-old, right? And then the car is filled with marijuana smoke, and you have a veritable pharmacy of dope in the car with you. This isn't the first bond violation, and you also have a gun. You have so many bond violations that your bond is now at 45,006 on all of our cases. And I told you, when you got out, if you had any issues, you would be going back to jail. I told you no diluted samples. I said no positive samples. Strict compliance was required. You have now five diluted samples.
And this, just so you can see it. It just comes back as an abnormal levels of keratin, but everything else is negative.
I'm taking everything you say seriously, Judge. Everything.
You can't tell that though. You can't tell if he's using cocaine, benzodiazepine, phencyclidine, because it's diluted.
I will take another test right now.
I don't care about tests now. The 5 prior tests that you've had have all been diluted. 5 prior tests have been diluted. I'm now revoking your bond again. Goes with you.
Should we give him a test on Thursday and see if it comes back?
No. Mr. Walker, you have a freaking pharmacy of illegal drugs in your car with a 3 to 4-year-old in a plume of marijuana smoke.
I've been taking everything you say
Time
seriously.
and again, I can't get through to you.
I've been taking everything you say seriously.
No.
I'm completely sober.
Judge, what would you be setting his new bonds at?
90,007 on all of them.
I think they have an offer right now, or Pavel gave us an offer that if he enters felony probation, they'll dismiss his misdemeanors. So let me see if
No.
The prior chief.
Oh, he's not up there now.
No, Pavel, the chief here,
Okay.
before he left.
No, but I thought you meant he, like in the felony, because he
Oh, I
moved to
see.
felony court.
No, yes, Judge. Yeah, so he had offered us if we get any sort of felony probation, he'll dismiss the misdemeanor. So I'll see if he wants to work that out. We'll try to-
If they do that, great. Well, what I want to do is I'm going to set him up for a TRAS because I don't know what he needs, man. But
Yes, Judge. And I think they're planning on doing that in felony court anyway. So let me,
it looks like he's got felony court, what, a week and a half?
yes, Judge. All right, thank you, Your Honor.
Thanks, bud. All 3, 90,007.
How much each?
Each 90,007. And 7. 7.
That's a lot of money.
Say it again.
We had an arraignment walk-in late, and.
Yeah, let's do it.
Page 20. Rucker.
Mr. Rucker has an open warrant. Uh-huh. You have a possession of a controlled substance that they issued a warrant out of the 176. You're being at no bond.
What was this, sir?
You have an open warrant for a felony possession of a controlled substance. Do you show the open warrant?
I don't have.
You had one. You don't have one. You had one. And now it's in warrant status. You have.
Well, I went to court last Tuesday. It's on someone had to go to court and today.
I'm showing that you have an open warrant. I'm going to have Deputy Martinez verify it to make sure that it's true. I can't let you go yet, but if it's not an open warrant, I'm going to let you go. But if it is an open warrant, it's a felony warrant, I can't let you go.
Yes, sir.
Because then I'm going to get in trouble.
Yes, sir. I went to court Tuesday, right after I got out of jail, but they sent me to the wrong court. It's a RIC, you know.
Okay, let me run it. I'm gonna give you a lawyer too, okay? You pointed to
What?
Oh, yeah, we need to introduce you to people.
Oh, yeah.
Okay, so this is Michael Haddad, everybody. He is our new chief DA. Guys, I forgot your name. I didn't catch it. Erica? Okay, hi, Erica. And I know you, Alex. What was your name? Morgan. So you guys have the ability to hang out, but you can't do recommendations, right? They don't have a bar card yet.
That's correct, Judge. That's correct.
We know when they're gonna get a bar card, or is it gonna be, are you guys still in law school?
Yeah, we've already taken the bar, so we're just waiting on our results.
Oh, I'm so sorry. What month are we in now? September? So you took the July bar.
Yes.
When do the results come out?
October 7th, 8th.
Oh, you're like right around the corner. Oh, I'm so sorry. I remember those days, man. That's brutal.
It was only 2 years ago for me, Judge.
What?
Yeah.
Really?
Yeah, I'm brand spanking new, a couple of years. Yeah.
Fantastic.
I just got off my first felony stint, so. Yeah.
Was it good? Do you enjoy
It was
it?
great. I was in Kelly Johnson's court, tried a few cases, then they put me in juvenile for a couple months.
So were you there for the trial with, she's had two big cases.
Yeah, were we talking about the child murder case?
There's son, what was his name?
Oh, Armstrong.
Armstrong, yeah, were you there? for
A.J.
that?
Armstrong, I was not there for A.J. Armstrong. That was right before my stint.
Okay,
Yeah, but we were there for Daryl Wheatfall, which was the appeal for punishment. So we tried a whole capital murder, just punishment phase. Brett, Sarah Seeley, Jenna Oswald, and Savannah Hooper tried that case, just all punishment. And what's his name?
the other one, there was the other one.
Yes,
Coulter,
Brian
that was the
Coulter.
other one.
Yes, Brian
So
Coulter.
He
Yeah.
was the allegedly, was it the baby or?
Yes, it was his girlfriend's 3 children, 3 sons. He just like kept him in a room in their apartment. One of the sons had died from his neglect and his abuse. He just put a blue tarp over him and left the kids in there with their dead brother for months while they moved to a different apartment. So while they're sitting there letting their sons rot in a locked apartment room, they're off doing whatever they're doing. Right now,
Crazy.
there's still a pending case on the ex-girlfriend. So she's still got a pending case for tampering with a corpse and I think aggravated assault SBI of a child are the 2 charges for her.
She's still in custody, I don't imagine.
She's still in custody.
Okay.
Yeah, she's trying to work out a deal. No, but Brian Coulter, that was a very intense.
I remember
trial.
looking at the pictures on the media. He's got this big, long, flowing hair. Looks completely different than what he did when they
Got that
first.
big tattoo on his forehead or neck, I believe, says warrior on it, like a soldier, warrior. Yeah.
Yeah, right. Okay, we're done. Go. Guys, have a wonderful day.
Thanks, Mike.
Thank you. Great day.
Comments? Hey.
Approaching on Angel Pena, he tested negative. The last time we were here, we did discuss, because he does have a job now with his uncle, we discussed him not having to come in twice a week.
Do you have notes of that? Vic, how about Pena? Pena was supposed to test a couple times a week, right? Because we've had a lot of issues with him over the years. And was he also supposed to have a device on his ankle?
He has a device. He has one now. And when I called him yesterday after you texted me, he said he thought.
Mr. Pena.
He said when we were here last time, he remembers that we said he didn't have to come twice a week, and he immediately was like, "I'll be there tomorrow morning to test," and he tested negative. So I do think that he genuinely did not believe he had to come twice a week.
You tested clean today. Great. I'm proud of you. Good job. Really. That's all we're asking for you. Don't use any dope and just, be a productive member. Do something with your life. If you don't want to go to school, okay, that's on you. But at least do something with your life so you're not out there creating mischief, right? Because when you have too much time in your hands, you're going to get in trouble. What are you doing there?
Well, I'm working, like making portraits.
Doing what?
Carpentry, like making portraits.
Great.
Stuff like that with my uncle.
Okay. Are you working full time? Full time?
I'm not full time, but like I work most days.
Why not full time?
Because my uncle travels to Louisiana, so like he gets little jobs here and there in Houston, and that's when I go work with him.
You cannot go to. Did we put a travel? But that doesn't mean that he can't go to Louisiana. Or do we have a curfew on you?
Yeah, we have 7 to 7. Yeah.
I'm glad that you're working. Good. And I don't want to prevent you from working elsewhere. But the problem is that if I let you out, it's just, I'm scared to do that,
That's fine.
Where are we headed anyways with this thing? Because
The truth is still missing labs. Talked to the chief. He said that the lab was never accepted or something by the testing place. I know.
None. So it's 182 days old. Tell me about the labs.
I understand, Judge. So this is becoming a problem in Harris County. A lot of UCWs, they're not actually testing the narcotics in these UCW cases that we established PC with the narcotics. I confirmed with Morgan yesterday. She called the lab directly. It was submitted. They never tested it. Unfortunately, the officers have to follow a policy that they're not doing when they're submitting it in limbs. We called the officer and had them do it again yesterday. The lab confirmed they're expediting the request, but I can't tell you how long it'll take.
I'm not going to wait like months. I can give you like a final deadline,
Could you possibly give us 30 days, Judge?
Done.
Okay.
That's it. If it's not done in 30 days, then we move forward without the labs. And if you don't have the labs, then there's just no probable cause, right? Okay. So I'm going to give them a final 30 days. If they don't have it done in 30 days, then we move forward without it. Pena, just stay out of trouble. Don't use. That's all I'm asking. You're doing great so far. All right. Okay, man. If they haven't found anything and the case is going to go away, then I don't need them here. Okay. But if they're able to get everything, we need to make a decision whether we're going to go to trial or not, or he's going to take something else. Okay. Okay, guys. All right. And then
From this, I'll write down the November 4th date. November 9th. This is at what time?
I'm
Get it right.
yeah, let me get the file real quick. And then I've emailed Holly, who's in charge of it. See if I can get a file real quick and then we'll try to print it out for him.
Is that Williamson?
Yeah, I'm doing it. Okay. Kavita, I'm sorry.
Vidales.
Good morning, Mr. Vidales.
392. Ezra Williamson.
Okay, so Mr. Vidales, you have 2 thefts and a criminal trespass that are open. I have the criminal trespass at 10,003 because you don't come back. How come you don't come back? I took a shower.
A lot of people have been setting me up, so I'm trying to go back. I'm trying to go to like to a group home. After Broadway, I ain't trying to go back to Broadway no more.
If you come back to court,
Yeah.
good things happen. When you take off, all you do is you put on orange, and then all we do is we make your bonds higher and higher and higher, and that's all that happens.
Yeah.
When you come back, we help you. We want to help you. We want good things to happen for you. But when you take off constantly, you know, this is what happens.
But he understands he's gonna get help and go to the housing and everything he needs at that point.
Are you on probation or parole? Is he on probation or parole?
I can see Judge.
Okay. What are we doing? Which, on which one? In Kavita, the newest theft. You know, are we setting him up to fail by doing this? Are we just setting you up to fail?
I'm gonna do it. I'm gonna do it.
You're gonna do what? Pick up another case? Yes, I know.
I'm not gonna pick another case. I'm gonna go to the group home.
He says he's gonna go to Cypress Creek
To
Hospital.
Cypress Creek, I just tell them Cypress I'm suicidal and they receive me.
No, I'm not gonna do this now, Mr. Vidal. This sets you up to fail because all this does is tell you it's okay for you to constantly take off, pick up a new case, take off, pick up a new case, take off, pick up a new case, and when we just give you 3 days in jail, boom, you get right back out. What the hell good in there is that for that? Do what?
I'm gonna do whatever it takes me to stay out of jail. I mean, I've been.
I don't believe that for a second, man.
14 tanks and I got him beaten up a whole bunch of times.
You got-
14 tanks. I've been in 14 tanks and I've been assaulted by a lot of inmates. I'm getting beaten up over and over by a lot of inmates. They took it.
Yet,
Yeah.
all you do is pick up new cases and continue to abscond. If you're telling me that you have all these mental health issues and we are basically just doing catch and release, no. I'm done doing that, Mr. Vidales, because that tells you it's okay for you to keep doing what you're doing and we're not addressing the underlying problem.
I'll fix the issue. I'll fix the issue. I'll fix it.
I don't believe you. I'm sorry, Kavita. Can't. What I'm gonna do is I'm setting you up for a TRAS because I want to know more about you. I want to know everything about you.
I'll fix the issue. I'll fix it. I got it.
I don't believe you.
What do I gotta do?
And a TRAS.
What's that? What's a T-Rex?
It's an evaluation to see what's going on in your life, to see why you keep coming back to us and why you keep taking off. I'm done with catch and release, Mr. Vidales. It's not happening again. I love the
I gotta stay
tattoos.
more time in jail now.
That's right. You got to stay more time.
I'm finna catch out in this tank right now. I'm finna catch out. I'm finna point out 10 people. I'm finna point out 20 people. I'm finna keep on pointing out people catching out from tank and tank and tank. I'm letting you know, my people situation gonna get real worse at this point.
Okay, let's go. Mr.
What does that mean?
Yeah.
Are you rapping?
No.
Yeah, I'm just gonna go ahead and point out anybody who I gotta point out.
That homeboy up for a T-Rex. I'm not. Hey,
I'm getting threats in the whole tank.
I'll fix that for you. Hey, can we get him into, I'd like to get him in. We're gonna get him into another tank, but let's do a T-Ras. And if he starts playing around, we'll do another T-Ras until he's plays the game, I guess, you know, but no. Shreya, ready?
Yes, Judge.
Smallwood, you said, right?
Yes.
Good morning, Miss Smallwood. How's jail? Really? Wow, you have been a very busy person. Let's go through your stuff. So at the outset, it looks like you're wanted out of state for one reason or the other. I have no idea. I know you're going to tell me it's all gumdrops, tulips, and little bunnies jumping, right? But how I get to know you is how you look on paper, right? What I see now, you have a credit card abuse that's open, a felony credit card abuse, a felony theft, 2,500, 2 or more times open, a felony fraud, another credit card abuse open, another credit card abuse open, another felony theft open, an aggravated robbery. Is that it? And then what else you got open out of state?
She has 2 thefts of properties from Houston County. Alabama.
No kidding.
Yes.
What would you like? A unicorn.
Judge, I understand and I see it, but she's got a lot of skin in the game. She's got about, I don't even know how many thousands of dollars of bonds on felonies that she's made. And technically Alabama is just minor thefts. Realistically, we don't want Alabama to spend the money to come get her. She's gonna put up her own money, and you know what? She's gonna have not only this bond, she's gonna have all those other bonds up in the air, and so she's got a lot on the line, and we discussed that. Now, the failure to appear, Judge, I know just one more argument, was only because she was in jail here. She was keeping up with the Alabama case. Does not bode well the number of cases and types of charges, of course not. But she technically, it was not really a failure to appear, it's just, I mean, she couldn't go. She has been keeping up with it. Her family is very invested in helping her and got a lot of financial investment. And as a side note, I mean, she's been feeling it. Her sister got shot in the face, 20-year-old sister shot in the face, and she had her funeral yesterday and she missed it. So
that sucks.
She understands like what's been going on and she's feeling it.
And sister died.
My little sister.
That sucks.
Her boyfriend shot her in the face was in the news. So she's very, you know,
It's awful.
I'm not speaking for you, but is this something where you are committed? And she understands if she doesn't go within 14 days, it's not just this bond, it's everything.
She has an open aggravated robbery of over 65 or disabled. So do I venture a guess that that is allegedly probably taking care of an elderly and she takes a bunch of credit cards and uses them? Is that?
I would have to see if there was an offense. But Judge, she's also had similar history in other states within the last few years as well. So we wouldn't feel comfortable releasing her on bond. We have concerns that she would be a danger to the community if we did so.
I think so too, Ms. Smallwood. You've repeatedly shown to us that you don't care about our public. You don't care about our bond conditions. And that is evidenced by your 1, 2, 3, 4, 5, 6, 7 open cases here where you have been filed on in multiple dates. And you also have multiple offenses in Alabama, and then you have similar offenses in another state. So essentially, you are playing hopscotch with the states with criminality. And you want me to give you a bond? Really? I would like hair, but I'm not going to get it. That's just a sad fact of life. Like here, it's also a sad fact of life. I'm not giving you a bond because if I let you out, what's going to happen? Historically speaking, every 2 months you pick up a case. So if I let you out in 2 months, you're going to pick up another case. I don't want that to happen. Sometimes we have to protect people from their own selves. You are your own worst enemy. And now I'm going to protect you from yourself. I'm not giving you a bond. I can't trade.
Understood, thank you.
You know what I mean? If you, and not only that, all the money she's posted here, 1, 2, 3, 4, 5, 6, $60,000 bond. Whose money is that? All these are credit card abuse cases. She's getting money from somewhere, some other place. No. Sorry, man. You're staying with me. Just let Alabama know that I'm not, so that they can come get her. You know, the good news is that you've made bond on these cases. So we now give Alabama 14 days to come get you. If they don't come get you, then they'll file a dismissal. Or has she waived? Or
She
no?
has waived. What date did she waive?
September 25th.
Yeah, so you have actually 13 days. No way, Miss Smallwood. It's time to pay the piper. Thank you. Betraya, thank you for your tenacity.
I had something today.
Actually, afternoon. I'm gonna bring out Cory Seals. This is the one we had a mental health for. As you saw in the report, there is extensive history. He was found to be competent now.
He's found
to be competent.
Really?
I thought. Yes, that's what I.
Have you been?
I was kind of surprised with it, Judge, especially with his history. And so I can give you kind of a rewind and a present. The reason why, if you can recall, that I asked for the evaluation, when I was trying to go over his cases with him, I started off with the felony. He's adamant, I don't have a felony, I don't have a felony, I don't have a felony. I try to show him on my computer that you have a felony, and he goes into a ball in the cell, lays down, goes into a ball, right? That's when I asked for the mental health evaluation. Come back, I'm reading some things, and I'm like, wow, I was kind of surprised with how he was with the doctor as far as on the evaluation or the examination. So I was thinking to myself, maybe he was coming down off of drugs possibly, because you know that you can have two things can be true. You can have a drug issue and a mental health issue, and maybe he's doing a little bit better now, because I was a little bit surprised with how he was able to relate to the doctor. Today, after speaking with the state and getting a time served offer, I wanted to relay that back to him. Again, we start off with the felony. This time he gets very upset. I do not have a felony. And I'm like, Mr. Seals, I have no reason to lie to you. You do have a felony.
Able to bring him out and talk to him?
Well, that's what I was hoping, because if we can, I disagree with the doctor's evaluation, but at the same time, if we can.
I agree with you. You know, maybe it depends on who the doctor he sees. Why don't we get, you know, in life, when you don't get one opinion that you think is right, what do you do?
Second.
Right. And I think that that's what we need to do. Now, if we get a second opinion from another person and they say the same thing, I don't know. So Seals, how's jail? You, in the 7 years that you and I have been dancing for together, you have never, ever, not once, ever appeared on your own. You get out of jail and do whatever you want to do, and you pick up a new case, and then we let you out, and you keep doing it over and over. The days of catch and release are over. Do you understand? You also have an assault in the felony court as well. It looks like an assault of a employee of the jail. Is that what that is, guys?
It is, Your Honor.
It's a detention officer.
It looks like you got into a fight with someone at the jail and they charged you with a felony assault. This was June 1st. What I would like to do is have you talk to one of our doctors to see where we go from here. Do we need to send you to a place where we have you evaluated and see how we can get you forward with your life? I don't know. But what we are doing now is not working. I will not take any more pleas of guilty on your cases. Do you understand? So let's try to get a second opinion. Regardless, with the felony open, it's not going anywhere as it is anyways.
Yes, Your Honor.
And it looks like the felony is set for October 8th. So is it possible that we ask for a different evaluator for a comp? Or do they only have one person?
No, they have multiple assessors. I think he did a TRS or was it a competency evaluation?
Competency evaluation.
Just a comp evaluation. And they're saying that he came back competency, but do you understand that you have the felony open? Do you understand that you're charged with a felony? But you have one that's open. No what? Yes. I'm telling you, you do. Say that again? You mean you don't have a felony on your record or you're not charged with a felony? Which one? You
might get charged with a felony currently. So, yes, that's what we talked about. You have to charge with felony assault.
Mr. Hatton, I think he's right.
No, Judge, I'm not talking about his history. I was trying to, this is the same thing we talked about. You're charged currently with a felony. That's what we're talking about. You currently have a felony charge, an active felony charge for the assault of a public servant.
You are right. You don't have any felonies on your record, but you were charged with a felony right now. But you're right. You have no felonies on your record. That's right. I don't see it. Do you?
I don't have it.
You have no felonies on your record, but you are now charged with a felony. Do you understand that? It's okay. I want you to know what you're facing. That's it. And you got into a fight at the jail and they ended up charging with a felony now. You remember that? Okay. So we would like you to talk to a doctor to see where we should go from here. And then we'll see what they say.
But that's why, if you could read the report, as far as the interaction that the doctor said, as far as how he's talking about his own case, you can see it now. I don't see how that was possible. As far as the doctor was saying that he was able to talk about his case, to relate as far as, now he did, I think he was only focusing on his felony attorney, which I can understand that as far as, remembering who his attorneys are. But he never makes mention of a second attorney. He never makes mention of the case itself, but the doctor, I guess, said that he had a better interaction that I haven't seen. What you see now is what I.
Are you taking any medication? No.
In jail, he was prescribed some antipsychotics, Judge, because he was diagnosed multiple times with schizophrenia and I forget what the other diagnosis is, but it's very akin to schizophrenia.
Will you take your medication? Will you take it if they give it to you?
We'll try again, Judge. Let's try again.
Let's see what they say. And maybe, say it again. Benadryl? How do you get Benadryl? In the jail? Do they give Benadryl in the jail? Really?
Prescribed, yes.
Okay. We would like you to talk to a doctor, though. Yeah. Well, you have a felony that's open. We can't do anything here. But you do. You do. You have one that's open. You saw.
Can I ask him if he remembers the facts of the case?
Sure.
I'll just talk after. Sir, do you remember possibly kicking a detention officer in the groin after trying to transfer you to your cell? Do you remember anything like that happening?
I don't know. I guess let's have him talk to someone else and see where it goes, and then. But I think that we would be underserved by just continuing to plead guilty and just let him out. I don't think that's the right thing to do.
There's something that's missing, Judge. Sorry.
Yeah, I'm with you. I agree. And, but it could be also, you ever watch the movie Primal Fear?
Oh, definitely.
So who knows?
That's what I was
don't
worried
know.
about too, Judge, because after reading the report, that's why I talked directly to the state, because I was like, well, maybe if there is something that was bothering him before that he came into the jail with, maybe I was talking to him too fresh off of that, if there was some kind of substance abuse, right? But then when, I had the same experience today as I did the last time, I just,
Let's try it again. Can we?
I just need a little bit of clarity. So am I scheduling him for a TRAS assessment?
No,
Okay,
no,
so
another
actual
comp.
competency evaluation. I can't-
We want a second opinion.
I can't do that. Also, so I generated the motion and the order for that. It was done. It was found competent. So I was told that if another one is done, it would be for sanity. But are we doing another competency?
Correct.
So that I need to check with Sylvia, because I don't know how.
Okay, I can reach out to her. Don't worry. We'll try. We'll reach out to her to see how we can work out the nitty-gritty and get it done. Talk to them and let them know what's going on so we can figure out how to help you. We want to help you, Mr. Seals, so you stop coming back to jail. Okay? Okay. You know how when you take, well, not, I don't know if you know, but like when you take certain, drugs, you get, and then you get drowsy, you're not in the right mental state, you groggy, and I feel like that's how it is.
It's weird because what you're seeing, I think, is him trying his best to relate back to you, because I'm telling you what I saw in that report. I don't see how the doctor came up with that. And I'm a former judge. I'm prosecutor. I've done plenty of competency hearings where I'm arguing both sides, and I don't see how they got that from that report, because what you saw, and I've sat there and I've been patient with them, talking with them or whatnot. The first time when he got into a ball like that, and I do a lot of mental health, that was like a clear indication of, and a lot of times, the paranoia that's associated with schizophrenia. So when I saw that diagnosis, I was like, okay, that's on par. But as far as how he was acting during that interview, I've never seen that. So I was expecting to see something
Could it be
different.
possible they gave him the drugs that he needed and he was,
And that's what I was thinking that could be possible,
now he
because it
just
wasn't.
hasn't taken it lately and
The jail has prescribed him at different times during his stops, drugs for his, or antipsychotic drugs. So we know that beyond multiple hospital stays that he has been prescribed in Harris County those drugs, right? So I'm not sure, there's nothing in the report as far as saying whether he was medically compliant, at that time, or I don't remember. It could be, but I don't remember seeing that. So again,
I'll reach out to Sylvia. We'll get someone else to do it. And unfortunately, it's gonna take time, but I mean, he's here anyways. because
And
of
that's
the
kind
case
of the thing I was
upstairs.
trying to tell him, that's why he got so upset about the felony again, because I was just trying to get him, make him aware of that, because if you did do the time served plea, you're not going home. It's not gonna be like that. And I know how that reaction could be if you're thinking that I don't have a felony, like you just heard him tell you, I don't have a felony. And this time he was adamant, he was angry. about me even saying it again or whatnot. I don't even think he said it from again. I think he thought it was the first time. I don't even think he had a connection from the last couple of times that we talked that I'm the same person. Because he doesn't mention me at all on the report. He only mentions old white lady. That's who he refers to as his attorney. I'm not an old white lady.
Let's see. Yeah, Natalie Schultz. Yeah.
Don't tell her I didn't say that. I'm just saying I'm not an old white
Not old.
lady. All right, thank you.
All right, thanks.
All right, Judge, page 8, Escada, Ruben.
Is that the last Spanish speaker?
Yes, Judge.
Okay. Do you have an arraignment?
I have a bond violation.
Okay, let me just, sorry, do you have anywhere else to go?
No, this is all I have today.
Okay, let's do the arraignment.
Okay.
Yeah. This is Esqueda?
Yes, Judge.
Okay.
On page 8.
Ruben Esqueda,
Yes.
you were charged with assault of a family member. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
The complainant and the defendant were dating at the time of the offense. On 9/21/2024, officer was dispatched to a disturbance located at 724 West 11th Street in Harris County, Texas. Complaining witness was asleep when the defendant began yelling and screaming at her. Complainant could not understand what the defendant was saying due to the defendant being high on mushrooms and intoxicated. Complainant decided to leave the residence to avoid an altercation. Defendant then grabbed both of her arms, causing pain. Complaining witness tried to get away from him, and the defendant scratched her on both of her hands and forearms, causing pain.
Do we know if she wants to have contact with him?
It looks like someone reached out and spoke to her. I don't see anything about no contact, but she said that she just wants him to get help and it's over.
Mr. Esqueda, I'm going to find that there's probable cause to go forward with the case. I'm now sending you for a drug test. I want to know what, if anything, is in your system right now, and you're to come back. If you fail to come back, I'm going to revoke your bond. I will issue a warrant, and I'm going to make it extremely high. You will not get any more PR bonds. As of right now, I'm ordering you not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, I'm going to put you in jail. And if you continue to use, I will hold you in contempt, slap you with 180 days, probate it for 2 years, and put you in a rehab facility. Do you understand? If you are not up now, I'm giving you the opportunity to stop on yourself. If you're unable to do it, I'm going to do it for you. And I promise you're not going to like the way that I did. Do you understand? Okay. Vic, I'd like to send him for a drug test, and then we'll have him come right back.
All right, right this way.
Okay.
Next,
Judge, he
is-
also has a portable device on the magistrate docket.
Does he? Okay, so let's have him test now, and then when we come back, we can discuss it. Thanks.
Okay, right this way. Go ahead and sign for your reset, please. Okay, Judge, page 3, Augustine.
This is Miss Augustine.
Yes, Judge, page 3.
You now stand charged with another case. You now are charged with harassment. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
The complaining witness, who is the ex-boyfriend, made a report to officers that his ex-girlfriend, the defendant, was sending him multiple text messages threatening to harm and kill him. Specifically, the defendant sent, and I'm calling GD to fuck your shit up. You said some fuck shit like that, I will kill you, I promise you that. Complainant stated that he was in fear of his life.
Ms. Augustine, I'm going to find that there's probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to have any contact with this person whatsoever and not to be in possession of weapons. You picked up a case while you're on bond. Guess what happens now? Guess what happens, man? What is the one thing I asked you not to do? What have you done? Correct. Your logic is impeccable. So guess what happens? She goes with you. All right.
All right, Judge, tell me page 8.
Oh, okay, Mr. Esqueda, come on up. Tell me, what does the complaining witness want in this case?
So Judge, per the complaining witness, she wants the defendant to come home for moral support.
Are kids involved?
I don't see any children that were
It's Mr.
mentioned.
Esqueda. How many children do you have?
I have 2.
Do they
The
currently
baby's at home with her, he's 2.
have kids with this complaining witness? Okay. 2 of them. 1, and it's the 2-year-old.
He's 2-year-old.
Okay.
His birthday's October 29th.
Piece of advice. When CPS gets involved in your life, it's an absolute nightmare. You will have to hire a lawyer. You will have to do family plans. You'll have to do all kinds of crazy things. When you pick up cases, when you have little children, especially when drugs are involved, they're invariably at some point going to find out and make your life a living hell. No more. I'm going to drug test you like crazy. I tested you today, you came out negative, which is great. But I'm telling you, I'm going to continue to test you. You don't know when it's going to happen, but it's going to happen. And if I find that you're using, and I don't care what you are using, I don't care what it is, because this includes alcohol. So if you try to tell me, oh, I was taking mouthwash, I don't care. You cannot use anything that has alcohol in it. You cannot use PCP, mushrooms, psilocybin. You can't use marijuana, anything with THC in it, oil, gummies, vape pens, tequila lollipops. I've heard it all, and no means no. If you have a problem, you better address it, because if you don't, I'm going to do it for you, and I promise you're not going to like the way that I do. Do you understand?
Yes.
Are you okay with him going back home?
Judge, no, and the reason being is the offense report indicates that this defendant entered the room where the complainant was sleeping with their 1 child, being aggressive towards her, screaming towards her, and assaulting her in front of the child. At this time, the state does not believe that it's appropriate for the defendant to be in the vicinity of the complainant or his child.
What about what she wants to?
We understand, Judge, but in domestic violence cases, you know this, Judge, better than I do. 99% of the time, they want the defendant to go back into the home. They always want that. The state's position is for the safety of the community. There at least be a cooling off period of 30 to 60 days. And then, Judge, we can reapproach and see if something's changed. If everything's still cooling off and it's fine, then maybe we can reconsider doing it. But at this time, our position is not to allow the defendant back in the home.
What do you do for a living, sir?
I'm an inspector. Text code trim, we do high pressure valve systems.
What kind of income do you make a month?
Well, if I make overtime, about 3.
What does your wife do?
Nothing.
Just takes home. When was the order of protection placed? Look at what the magistrate did with the order for protection. Michael.
Yes, Judge.
Take a look.
You're asking when it was signed, Judge?
Yeah, initially I was like, but it looks like that the magistrate even allowed him to go back home.
Right, I understand, Judge. I don't know what the prosecutor told the magistrate in probable cause docket. I honestly don't know. I'm just here telling you what I know from looking at the offense report. And I know that this defendant did this, conducted this behavior in front of his own child. Aggressive behavior, assaultive behavior, intoxicated on who knows what.
I mean,
And-
it certainly does concern me, the
Right.
use of mushrooms, especially when, I never like to, take fathers away from their babies because they need it. But luckily,
we should be opposed to just a cooling off period of 30 days, and then we can reapproach and reconsider this.
all right, we'll do it for a small amount of time, just cooling off. I don't want you to have contact with this person for now. I'll set your case off only 2 weeks. Come back 2 weeks. You need a lawyer to represent you. If you have any issues finding a lawyer, if you're unable to, come back and we can talk.
I asked when I was in jail for a court-appointed attorney. So financially not able to pay for one. I'm having to pay rent right now where my sons live, but sleep in my truck.
Okay, I'll appoint your lawyer today, Mr. Esqueda. But when I mean no contact, I'm absolutely serious. Don't, for the time being, we can always revisit. Absence makes the heart grow fonder. So just what I want you to do is really appreciate this, because luckily something worse didn't happen. It could have gone, it just could have been so much worse, and luckily it's not. We see so much worse things around here. It's awful, some of the things that we see. We want to prevent that from happening. And sometimes this is what it takes for you and everyone to appreciate it. So for now, I'll just have you take a seat at your box. Let me find your lawyer. Okay. All right. Thanks. Tommy was asking if we try any cases. And we love to try cases, just everything keeps caving. They either dismiss the case or they work it out, and then we just never end up in trial. When did we try a case? A month ago, right? Or 3 weeks ago? But we never, this year we've tried what, 5 cases maybe? Is ATX coming? Are people gonna come visit us?
She said she was.
ATX, are you gonna come
She said
visit?
it's a 3-hour drive.
Maybe we can get Bill to come too.
Yeah, Bill,
Bill, you wanna come hang out with us?
tell him bring that twig from his front yard.
All right, guys, we're gonna go. Thank you so much for hanging out with us. I have to run to another court to go do more work. Thanks, guys. Brian C, Cam, Spade, Jamie, KY, Lydia, Mike M, Need Coffee, Jason Powers, Raul Shaw. Hey, do you want to say bye, Vic? Is Michael here? Is Michael here?
Bye. I don't think so.
Mimi Praise.
He was on earlier. Bye, everyone.
Is he still using, what name was he using?
Victoria's a #1 fan.
Let's see if he's here. No, he's not here. Doug,
He'll
have a
probably hear the
wonderful
yells.
weekend.
He probably
Roz,
went to sleep already.
another Smith. Guys, thank you for joining us. I'm gonna see if I can go, well, no, I can't turn on the court's live stream.
Oh, no.
Okay, but anyways, guys, we'll see you bright and early Monday.
Bye.
Thanks for hanging out with us. And look, one more thing.
Another lollipop.
Kathy, I can't stop.
Won't
I
stop.
can't,
Oh,
can't,
it's a Diddy. Never mind.
won't, no, but I can't find them anymore.
It's a Diddy song.
Like I bought them all out. I've eaten them all up.
Oh my God.
I eat like 4 a day and I can't find them
You
anymore.
sound like a true addict.
It's ridiculous.
Well, guys, feel like I started that out. What'd you think? Did you enjoy selections? I hope so. It was quite a bit to put together, but it was fun nonetheless. I always love doing these little things. I always love having you guys come by and hang out and watch court cases with me and comment on the stuff. It's always interesting to see what people have to say about the stuff I put together live as it's happening. And we do this every Saturday morning at 11 a.m. Central Time, 12 p.m. Eastern Time. Come by, hang out. If you want to see more stuff like this, come by on the channel on Monday nights also at 7 p.m. Central Time. It's 8 p.m. Eastern Time. We'll be doing a Manic Monday with Judge Alex Manning, just so everybody has a heads up for this week. Oh, thank you very much, Victoria. Just so everybody has a heads up for this week when it comes to Judge Manning, she only had one docket, so we're probably going to be doing another one of these where we try and find something from the past and bring it in and see if we can put a little something together for Manning Mondays. Come back every Saturday and check this out. I want to let you know it's looking more and more like Judge Fleischer's going to be an every Saturday thing because I enjoy it. Now, whether or not we do a weekend review of all of the Fleischer outfits, that's another question yet to be answered. Maybe, but that's a new thing. We're probably going to be looking at, no matter what, every Saturday having at least 1 hour Fleischer block. That's an idea that's currently on the table. We're probably going to be moving forward. All that being said, love all you guys. Thank you for coming out. You make me want to do this every time I come on here and see all you here enjoying this week. Thank you for showing up, Victoria. Thank you for showing up, Mom. Thank you, Dreams, for helping out like you always do. Without Dreams, I can't make any of this happen correctly. I don't know what I'm doing. For now, music's over, and I'm done. Love you guys. Have a good afternoon. See you next time.